Welcome to another edition of Your Long Range Plan. My name is John Kennan, and my co-host is Paul Tierney. We are both estate planning attorneys, and we have offices here on Cape Cod and Sandwich and Quincy, Massachusetts. And today we're going to talk about wills and trusts. And I'm going to have Paul begin by defining simply or basically what a will is. Go ahead, Paul.
Well, a will is a legal document that people execute and have in place prior to their death. It does not take effect until they pass away. And to be properly executed, it has to be witnessed by two people and preferably notarized. If the document is notarized, then it makes it easier to have that admitted and accepted at the probate court when the time comes. So again, a will is a legal document that allows you to dictate where your assets go at your demise, and just as important, who would be in charge of carrying out the terms of the will. And that person would be called the executor or the executrix. Mm-hmm. After January 1st, that person is going to be called the personal representative. The probate laws of administration are changing drastically after January 1st of 2012. We'll probably have another program to talk about that, but for the moment, discussing a will, the definition of a will is a document, again, that you name somebody to be in charge of carrying out your affairs, which are depicted in the will, and the will also directs where the person's assets go after their demise, after the payment of debts, expenses, and taxes. So that is roughly the definition of a will.
So let's talk about the will a little bit more in the sense that there are certain components of the will. Basically, let's start with the legal aspects of it. Other than what's embodied in the will in terms of disposition of assets and who the personal representative will be, you mentioned notarization, witnesses, etc. Oftentimes, you and I receive emails and phone calls, if not a one-on-one visit by someone holding a document that he or she may have purchased at one of the local stores, well, without naming any stores, or going online. Are there any pitfalls in trying to produce a will yourself without the aid of an attorney?
You have to be very careful. If you do have one of those wills, I mean, a lot of times they're generic. They're made for all states across the United States, and it may not have the necessary language or the information in it that we need in Massachusetts for it to be a legal will. One of the things that I see most often with some of these do-it-yourself will kits is they leave off a lot of power clauses in the will. And if somebody dies owning real estate in Massachusetts, if you do not have the power in that document to sell real estate, then it's a separate process through the probate court to get a license to sell. So that has to be approved by the judge, and it's an additional process that could, be a lot of time and therefore money to accomplish something that would have been simply accomplished if somebody had had a valid will executed by a knowledgeable Massachusetts estate planning attorney.
Let's talk about the witnessing component of a will for the Commonwealth of Massachusetts. Specifically, if I may, that you must have two witnesses witnessing the execution of a will by that testator or testatrix, if you will, if it's a female, on the latter point. What happens if there's maybe one witness only? There's an omission, not two witnesses. What happens?
Well, then it's not a validly executed will. You need to have at least two witnesses, and like I said, preferably also a notary public. The witnesses are supposed to be independent. If any of the witnesses are also devisees of the will, in other words, if they're taking property under the will or if they're getting a bequest of cash or other assets, then they cannot be a witness. If they are a witness, then that bequest or divisee is void. So very, very important that your witnesses be independent. And again, you can have two witnesses without a notary, and if that were the case, then there's an extra step to get the will allowed when the person passes away through the probate court. And that would be to have one of the witnesses go to the probate court and attest to the fact that they were a witness at the time the decedent signed his or her will. If you can get all the assents from all the heirs at law, then that's a situation where you do not need one of the witnesses to attest to the probate court. And that's only the situation if the will is witnessed by two people without a notary public. If the witnesses are attesting before a notary public, then you avoid that extra step to get the will allowed at the probate court when the decedent passes away.
So needless to say, I guess what should be taken from this discussion regarding wills is that probably best that you consult with an attorney when constructing a will. And if you do try to prepare your own will, again, it probably would make a lot of sense to have it reviewed, at the very least, so that you wouldn't have some of these issues down the road.
Just like if you're purchasing a house. I mean, that's a big, major financial decision. It's a big financial commitment. You want to make sure that it's done right. You want to make sure that you have professionals involved to help you through the process. Yeah, you could do it yourself, but I always compare that to maybe fixing the transmission of my car. Could I do that myself? Well, probably not. But if I spent enough time and tried to figure it out, I could probably adequately do that. But you shouldn't try to do those things yourself if you're not an attorney. You should always seek qualified legal advice. It avoids problems in the future or while you're getting done what you need to have done. And when you pass away, I mean, passing your assets and wrapping up your affairs, appointing the people that you want to be in charge of that's an important event. That's a huge event, something that only happens once during your lifetime. So I think it's very, very important that you take that very seriously and you don't try to get out of it in a cheap way or a way that's going to potentially jeopardize what you're trying to accomplish.
So we've talked about some of the components, some of the mechanics of will construction. Is there anything that you think the viewers might want to hear or that we should share with them, because this is an educational program relative to distribution or disposition of some of the property that a decedent or someone creating a will might have to consider? For instance, someone owns a home. They own the home outright, no mortgage. They want to leave that home to two of their children. They've got some money in the bank, and they'd like that to be distributed equally. How does one handle that typically?
Well, every situation is a little bit different, and that's where it's our job as professionals to try to find out exactly what the client is trying to accomplish. Many times, if they want to leave their assets equally to, say, all of their children, and there may be a house involved, there may be cash assets involved, many times it's best if they just say, I leave the residue of my estate, which would include everything, whether it be the house, stocks, bonds, real estate, cash, everything equally to my children. Because there may not be that house involved at the person's date of death. The will only affects assets that exist at the decedent's date of death. So if you did your will today, you may have a house, you may have all sorts of different assets that may not exist years from now when you pass away. I'll never forget, several years ago, an attorney up in Boston area was doing some planning for a husband and wife client, and the husband was a big Boston College supporter, and the wife went to Emerson College. And the husband, who was the BC supporter, used to work for Digital Corporation. And he in the will, they left all the digital stock at the death of the last to die of the husband and wife to Boston College. And they left all of the other stock that they had, which was kind of insignificant compared to the digital stock, to Emerson College. Now, what the clients really wanted to accomplish is they wanted the bulk of their estate to go to Boston College. But because at the time, Digital Corporation was up around $190 or $200 a share, that made up probably 90% of the married couple's estate. But by the time the last to die of the married couple happened, Digital had gone way, way down in value. It had merged with, I think it was Hewlett-Packard or some other company. Mm-hmm. And at the death of the second spouse, which was the wife, those shares that were originally Digital shares were worth about 20% of the overall estate of the married couple. Mm-hmm. So Boston College ended up getting 20% of the estate, and Emerson College ended up getting the 80% of the estate. And that is not what the couple wanted. So that's the danger of allocating specific assets to specific either individuals or entities. You have to be very, very careful. I would much rather, and I usually recommend, that you go by percentages, because the value of your estate is going to change from today until date of death.
And that can be accomplished by a will?
Yes.
As well as a trust, which we should probably talk about right now as well. Mm-hmm. That's a mechanism or an instrument that you and I constantly use, where we're attaching certain percentages to of something to be distributed to individuals or entities and what have you. And speaking of trust, if you could outline the components of a trust and maybe the differences as you go along in the utilization of a trust when estate planning versus just a simple will, if you could.
Sure. Well, first of all, a trust is a legal document. It's created by an attorney, typically. There's two types of trusts. One is what we call a living trust. That's a trust that's created during your lifetime. That can be revocable, or it can be irrevocable, or it can be a hybrid of the two. Another type of a trust is a testamentary trust. That is a trust that's created under a will. It only comes into play when you pass away. So you can't put anything into that trust now while you're alive, and there's only so many things that you can do with it because it only comes into play after you've passed away. That's what they call a testamentary trust. Mm-hmm. The trust is composed of a couple of key positions. One is the trustee. That's the person that's in charge of operating the trust. And if we're setting these up for individuals during their lifetime, we usually have the individual be their own trustee. Now, a second position under the trust is the beneficiary. That's the person that the trust document and anything that's put in it is going to benefit. And there's various time frames that we look at. One time frame is who do we benefit during the person who set up the trust's lifetime. So that can be a whole set of beneficiaries. Usually it's just the individual himself or herself. Then the trust document would go on and talk about what would happen after the person who set up the trust, which we usually call the grantor, who the beneficiaries would be after the grantor passes away. And in the typical family situation, we typically want to benefit a surviving spouse and or children. And how we benefit them really depends on the individual and their estate plan. We can be as creative as the individual wants, and we try to, again, elicit from the individuals what they're trying to accomplish if we're going to go that route.
I recall you and I, maybe several years ago, worked on a trust together. There was a request, a specific request to fund the trust, which we'll get to. We deeded a property to the trust, and the trust embodied operating language similar to an LLC. There was all kinds of operational language about how the property would be maintained, managed, contribution, et cetera. So that became quite a pretty voluminous trust in terms of the operating powers as it related to the house. And that's what you're referring to in terms of it can be seemingly benign or as simple as 4 children receiving 25% each of a trust, or those same 4 children receiving that same percentage if and when or after certain conditions are met in the trust regarding a home, for instance, and the grantor's wishes for the way the home should be managed and maintained and used.
And that's why, again, I'm going to reiterate, it's very important for us as professionals to find out from our clients exactly what they're trying to accomplish. Because the complexity or the rules that you set up in the person's trust are really dependent on what your client is trying to accomplish. It can be relatively straightforward and simple, or it can be more complex depending on the individual beneficiaries involved and maybe some of the assets that need to be managed, again, depending on the client's situation. But one of the things that people always ask me is, hey, Paul, if I have a will, do I also need a trust? And the answer to that is, it depends. As a very, very basic recommendation, I think everybody, just about everybody, it doesn't matter who you are, but everybody should have what I call a basic will plan in place. A basic will plan would be a will where you name an executor, somebody who's going to wrap up your affairs, make sure that your final income taxes are paid, your debts are paid off, funeral expenses and things like that, and ultimately where any assets that are in your name at death are going to go. So that would be a will. Another document that's part of a basic will plan would be a durable power of attorney. And that's very, very important. That is where it's, again, a legal document where you're appointing an agent to act on your behalf during your lifetime. Doesn't take away any of your rights now, but when you execute that power of attorney, it takes effect immediately and lasts until date of death. And we'll probably do a separate show, a program on power of attorney at a later point. But that should be part of everybody's basic will plan. And the last document that should be part of everybody's basic will plan would be the healthcare proxy, preferably with living will language. Living will language would be language that says, in a nice way, hey, don't keep me alive by heroic means, if it get to the point where the person is in a vegetative state and there's no hope for their recovery. Again, the healthcare proxy goes even further than that, in that it appoints an individual to act as your healthcare agent if it's determined by your physician that you lack the capacity to make your own medical decisions. So your healthcare proxy would be able to make a medical decision for you if one was needed, if you were in that situation where some operation had to be done or some procedure, or maybe foregoing a medical procedure. Any type of decision like that, the hospitals and doctors want to make sure that you have a healthcare proxy in place. So that should be part of the base will plan, those 3 documents. Now, a trust, a little bit different. And again, depends on the person's situation. If you do have a trust, or you do want a trust, and I'll get into some of the reasons why you may want a trust, then you should still have a will. You'd want to have the will coordinate with the trust so that if you have some rules that you create under the trust as to how you want some assets managed or how you want to benefit some of your beneficiaries, well, if everything was not funded in that trust during your lifetime, then your will can have what they call a pour-over provision that gets everything else that's in your name at date of death. If you didn't get around to putting it into the trust, the will pour it into the trust. And I've had people over the years say, well, Paul, I'm funding my trust now. I just want a trust. I don't want a will. And I remember one time I let my client do that. We just did a trust, and about 2 years later, I got called up by the family, and we were dealing with the administration of the estate. And it turned out that the woman forgot that she owned a piece of land that was in her name at date of death. And if she had a will, that would have been clear that it would have poured right into the trust. But because she didn't have a will, then we had to follow the intestacy statute of Massachusetts, which is the state's way of making a will for you, and it didn't go according to the way the woman had her estate plan set up in her trust. So again, I need to reiterate the fact that if you do have some type of a trust plan in place, it should be coordinated with your will so that your will pours into the trust.
The latter point you just made triggered a thought. The individual who passed away was hoping to leave a trust that's essentially the directive, whether it's a will or a trust, it's a directive. And that's how you and I try to communicate to our clients. These documents should be perceived. All those things that we would like to have happen when we pass away are fully explained in these documents. And as such, they're directives. And in the example you just cited, brings to light something that I too experienced with a client who did not listen, I tried in vain to explain the necessity of having to craft a will, because if you don't, it just complicates things. Not only does someone pass away, and that's an entirely different matter entirely in terms of the grieving process, there's a lot of discontent, there's disorganization, there's chaos as to how the estate's going to be administered. And in your case, there was some property outside of the trust. Mm-hmm. You had to follow the laws of intestate succession. You had to fill out those documents that you said are needed sometimes when there are no powers to sell real estate in the will, so you had to execute or have the administrator execute a license to sell, so it's timely. You incur a lot of expenses. The average person's not understanding that. They're thinking you and I are just trying to make some extra money with the court, but these are the pitfalls or the traps for the unwary if you don't heed the advice of an attorney or you try to create these documents without the assistance of an attorney.
Yeah, I think if I could jump in, I think speaking on both of our behalf, we like to stay out of court. Mm-hmm. Unfortunately, especially the probate court, but all the courts in Massachusetts, as in many states now, are overburdened. Their budgets have been cut. The staff is overworked, underpaid, and it's not a very efficient way of getting things accomplished. So I like to stay out of court. If I do have to occasionally do the license to sell, if there wasn't any power clauses in somebody's will, or if they died without a will, to me, that's a pain in the neck. I would rather not do those type of endeavors. I would rather not have to, explain that to my client, because you're right, they sometimes just don't get it. They don't realize the process that we have to go through, the time, the effort, the aggravation, and then sometimes you have to follow up because they haven't gotten back to you with information that you need to go forward. So my point is that we like to avoid going to court if we can avoid it. And again, the way to do that is to make sure you have some pretty good documents drafted up by preferably an estate planning attorney.
Well, we've talked about wills and trusts. Oftentimes, again, we'll receive a phone call or have somebody come to us and say, I've been thinking about my estate plan. I don't have anything. And usually you and I will say, what does that mean? You don't have a will? And invariably, yes, I don't have a will. And then we'll hear something that might go along the lines of, somebody told me not to do a will because if you only have a will, the whole world will know what my business is. And I don't want the whole world knowing what my business is when I die. Someone said a trust would be better because you don't have to go through the probate process. I know what all that means, as you do, but if you could tell the viewers, I think it would be quite educational.
Okay, that kind of dovetails into reasons for having a trust plan. You don't have to have one. And again, I think our job is to find out from our clients what's important to them, and then we can make recommendations. But let's go over some of the reasons for having a trust plan or why a trust plan would be appropriate. Number one would be if people had minor children involved. As part of their estate plan, they probably should have a trust plan, because then you can dictate who would be in charge of your assets if you passed away, and you could pick certain ages that your minor children could come into their inheritance, if you will, as opposed to the age of 18, which would be the situation if you died without a will and your children were minors, or if you just had a will that said, I leave everything to my kids equally. When they became age 18, they could basically take their inheritance. Their guardian, if there was one in charge of them, would not have any legal say over what they decided to do. And in my opinion, age 18 in this day and age is way too young, way too inexperienced an age to be burdened with managing parental assets from an inheritance. So again, you can avoid that if you set up your own estate plan, your own trust plan, where you would say, hey, everything's divided into equal shares for my remaining kids, maybe when the youngest graduated from college. At that point, all of the major expenses are usually had been paid out, and then it's a kind of a fair way to divide up what's left over and pass them out to, say, all three kids if there are three children in the person's family. So that would be one reason for having a trust plan if you had minor children. Or if you had disabled beneficiaries, or beneficiaries that you felt really could not properly handle their own economic affairs. Well, if you had a trust plan in place, then you could stipulate that a person that you knew and trusted could be managing their affairs for them, or the inheritance that you left for them. That person would be what they call a trustee under the trust document. Or you could have the child be their own trust, maybe with a co-trustee. So that's, again, several reasons for having a trust plan. Another reason why a trust plan would be appropriate, especially if we're dealing with a married couple, would be to minimize or eliminate estate taxes. Now, they've raised the federal limit to $5 million per person, at least through 2012, but in Massachusetts, we have a Massachusetts estate tax on estates that are over $1 million. So many times it behooves a married couple to set up their own estate plan that contains trusts to minimize and eliminate Massachusetts estate taxes. So again, that's where we have to find out from them what's going on and what would be appropriate under the circumstances. Another big reason, and I hear this all the time, is avoiding probate. If people want to avoid probate, then if they fund their trust plan during their lifetime, then there's no reason to have to go through probate. And that's a way of making it easier to get it down to the people that they're trying to benefit. And it keeps it private. Nobody needs to know what is in the trust except for the beneficiaries of the trust. So there are many other reasons for creating trust plans that are beyond the scope of today's program, and we can maybe pick this up at a later program. And I think that's all that I have to say today, John, on a little bit about trusts.
Thank you, Paul. So as you can see, we're navigating some pretty complex waters when we talk about your long-range plan. And Paul Tierney and myself will see you again the next time we meet to talk about your long-range plan. Thank you.